so much for joining us today for this extraordinary NIW webinar. My name is Michaela Vrazdova, and I'm an immigration attorney at Scott Legal. Today, we are going to spend some time talking about the O1A, O1B, EB1, and NIW visas and green cards. And we will also answer any questions you have, so please feel free to put them in the chat box as we go over the PowerPoint. A few things before we get started on the presentation. So Scott Legal is a full-service immigration law firm. We assist individuals and companies pursuing various types of visas, anything from family-based, employment-based visas and green cards. And our main specialty is assisting entrepreneurs and investors. And we process a high number of extraordinary ability visas, green cards, and also NIW petitions. We will continue to have these webinars, and we will continue to have at least 2 webinars a month on different visa and green card topics. So please sign up for future webinars as well. And at the end of this webinar, we'll send you a few things. So we will send you this PowerPoint we will be using for your future reference. We will send you extraordinary and NIW visa guides. We'll send you a link where you can sign up for the additional webinars we'll be having in the future. And this webinar will also be available on YouTube, and we encourage you to subscribe and hit the notification button on YouTube, as we often upload immigration videos on various topics. So today I'll be leading part of the presentation, and we are lucky to have Jia Huang, who is an experienced attorney at Scott Legal, and who has processed many O1A, O1B petitions, NIW petitions, and she will be leading the second part of the presentation. And as I mentioned, if you have any questions, please feel free to put them in the chat box, and we will get to them as we talk, or at the end of the webinar. Perfect. So why don't we get started with the O1A, O1B visas and the EB1A green card. So O1A and O1B visas are non-immigrant visas, and then EB1A extraordinary green card is a green card that allows you to permanently reside in the US. So the O1A and O1B visas are just temporary visas that allow you to come to the US and stay in the US for a temporary period of time. So O1A visa is a visa for individuals who have extraordinary ability in the field of science, education, business, or athletics. And the standard for the O1A visa is that you have to show that you are one of the very small percentage of people in your particular industry, and that you have arisen to the very top of that field. And we'll discuss the O1A visa on the next slide in more detail. The O1B visa is also a non-immigrant visa, and the O1B visa is basically for individuals who work in the field of arts or in the field of motion picture and television industry. But the O1B visa is usually for artists, so just a couple examples, architects, designers, interior designers, singers, actors, people in those types of industries. The standard for the O1B applicants in the field of arts is that you have to show that you have received a distinction, and this means that you have sustained a level of achievement as evidenced by degree of skill and recognition that is substantially above that ordinarily encountered. So you can see that the standard for the O1B visa is lower than the O1A standard, just because for the O1B, you have to show that you are, a person in the industry substantially above the, the ordinary, and for the O1A, you have to show that you are one of the very few people on the top of your industry. So the standard for the O1B is lower than the standard for the O1A. Now, the EB1A green card, as I mentioned, is a green card and allows you to basically permanently reside in the US. So once you get the EB1A green card, it will be issued for 10 years, but you can basically just renew it indefinitely as long as you maintain your green card status, and also eventually apply for citizenship. So the standard for the EB1A green card is the highest of the O1A, O1B, EB1A standard. Just because when the government when they are granting the green card, the EB1A green cards for the people with extraordinary abilities, they just really want to make sure that those green cards are reserved for the people who are really on the very, very top of their industries. And so the standard for the EB1A is that you will have to show that you are one of kind of the small percentage of the people at the very top of your field, and you sustained a national and international or international acclaim, and your achievements have been recognized in your industry. And we'll kind of go over what you will need to kind of submit and show for the EB1A green card later in the presentation. Some of the, one of the questions we often get is, whether the fact that you have O1A or O1B for, you have had it for many years, and whether you kind of automatically qualify for the green card. The answer is no, just because, as I mentioned, the standards are different, and the EB, just because you have had the O1A or O1B for many years, for many people, yes, it does mean that, just because during those years they kind of achieved, they acclaim in their industry and they will qualify for a green card, but just because you have had O1A or O1B for many years doesn't qualify you for a green card automatically. And for all of these three categories, we have to show both that you have received these, you have these achievements in your industry, you have this acclaim, but we also have to show that once you come to the US, you will continue working in your field of expertise. So how we usually show it is, employment contract, or if you will work for, multiple kind of employers, then, your itinerary and things like that, just to kind of outline what you will be doing in the US.
Next slide.
Yeah, so let's discuss the O1A visa in a little bit more detail. So to qualify for the O1A visa, we will either have to submit evidence that you received a major internationally recognized award, such as, for example, Nobel Prize. And I will say, these usually have to be kind of major, kind of well-known awards by, by organizations such as the Nobel Prize. Or if you haven't received such an award, like probably, most of the people who apply for the O1A visa, then you will have to submit evidence showing that you meet at least 3 of the following criteria. So you don't have to meet all of these. I will go over, but just 3 of them. So the first one is evidence that you received nationally or internationally recognized prizes or awards. So these would be, not awards such as Nobel Prize, but kind of a smaller awards from other organizations or companies. And the evidence you would want to submit would be obviously the evidence of the award, like a photo of the award, and then information about the organization that gave you the award, just to kind of show that the organization is is a well-known organization in your field, is a prestigious organization. You would also want to mention perhaps some past winners of this award, if if those are some famous people, and you would also want to submit a letter from the organization, just kind of explaining why they decided, why they chose you, and what are their kind of criteria to how they choose the winner of the particular award. Second type of evidence you could submit is evidence of your membership in associations that require outstanding achievements. So these would be basically, any kind of prestigious associations in your field. You would want to submit evidence that, of your membership, that you are a current member, and you would also want to submit some information about the organization or association, such as information from their website, just kind of explaining what they do. And most importantly, you would want to submit information about how they select the members, because if you're a member of certain organization and they accept anyone as a member that submits a membership application, that's not that helpful for the O1 application. We would really want to show that this organization goes through a selective process, and they only choose people who have outstanding achievements as their members. The third type of evidence you could submit is evidence that that there is a published material in professional or major publications, newspapers, or other media about you or your projects. So, for example, if you are an architect and you kind of like were responsible for designing some build some famous buildings, and there is like media articles about that in some I don't know, Architecture Digest or some other magazines like that. And they mention you, you definitely want to submit those articles, and also just information about the media outlet, again, to just show that, yes, this media outlet that published this article is well known in the industry and is just a prestigious media outlet. Another type of evidence you could submit is evidence that that there is an original scientific, scholarly, or business related contribution of major significance in the field that you kind of invented or designed. So, for example, if you came up with some patent or like process that helped other people and kind of organizations in your industry, you would want to submit the information about the patent or the process, and perhaps some letters from some experts in your field that will testify why this process or patent or something you invented, why is it major and why is it original, and why is it important to the industry. Another type of evidence you could submit is evidence of that you authored scholarly articles in professional journals or other major media. So if you published, I don't know if you're a doctor or a scientist, and you published some major scholarly articles, you would definitely want to submit evidence of those articles, and again, information about the media outlet it was published in, to again show that it's a prestigious magazine, journal, or newspaper. Another type of evidence is you could submit is evidence that the salary or remuneration you will be receiving for your services in the US is high as compared to other people in the industry. So for this type of evidence, you would want to submit evidence such as your previous, W-2s or 1099s or tax returns showing, your salary. And you could also submit the employment contract for the US job that outlines the salary, and then just kind of submit comparison, what is the average salary in the particular area where you'll be working and in the particular field. And if your salary, is substantially higher than kind of the average, then yeah, you would submit evidence of this. Another type of evidence you could submit is evidence that you participated on a panel or individually as a judge, and you judged the work of others. So, if you judged any competitions in your field, you would want to submit evidence of that. So evidence, like email confirmations and things like that, showing that, yes, you participated as a judge. And again, information about the competition and about the organization that organized the competitions, just again to show that, yes, this was kind of prestigious competition in your industry, and they selected you as the judge because of the outstanding achievements you have. And the last kind of type of evidence you could submit is evidence that you are or you were in the past employed in a critical or essential capacity for organizations or establishments that have distinguished reputation. So for this, what we usually submit are letters from your current or previous employers, just kind of explaining, what the companies do and what was your role for the company. So if you had like a critical or, essential role for those companies, we would submit the letters from those companies. And yeah, again, you don't need to submit evidence of all of these. You just need to meet three of these criteria. Perfect. So now let's discuss the O-1B visa. So as I mentioned, the O-1B visa is for artists, people in the field of arts. So how can you qualify for the O-1B visa? So you can either submit evidence that you were nominated or you received a significant national or international award or a prize, such as, for example, Emmy, Grammy, Oscar, or some of those types of awards. If you do not have this, and again, like most of the people applying for the O-1B visa will not just qualify through this, then you can show that you meet three of these following criteria, and some of them are kind of similar to the O-1A criteria. So I will just skim through this quickly. So the first one is that you have been or you will be performing a lead or starring role in productions or events that have distinguished reputation. So this is, for example, if you worked for companies, I don't know, for example, as an interior designer or designer, and you worked on some kind of well-known projects, and then you would be submitting evidence of this, such as, for example, media articles about the projects and things like that. The second type of evidence you could submit is evidence that there are critical reviews or other published material by you or about you in media articles. So for example, again, if you're I don't know, for example, a designer or an architect, and there is like an interview with you in Architecture Digest or the Zen or like some of these type of magazines, you would be submitting evidence of that to to show that you are kind of like well-known and prominent figure in the particular industry. Another type of evidence you could submit is evidence that you had a lead, starring, or a critical role for organizations or establishments that have distinguished reputation. So this would again be kind of letters from your current or previous employers, just confirming that you worked for, these companies, and describing what was your role, like what you were doing for the companies, and if your role was lead, starting, or critical, you could meet these criteria. Another type of evidence you could submit is evidence of kind of a record of a major commercial or critically acclaimed success in the performing arts. So this would be, for example, like if you are I don't know, like a member of band, or if you're a singer, you would be submitting evidence of kind of sales, like how many tickets to your concerts were sold, how many videos, or how many kind of CDs and you sold online and things like that. So that would be this criterion. Another type of evidence you could submit is evidence of significant recognition for achievements from organizations, agencies, or other experts. So this would be basically like letters from some experts in your field, just confirming and testifying to your achievements you have achieved in your particular industry. And then another type of evidence you could submit is, again, just evidence that you have commanded a high salary. And those would be kind of like the same type of evidence we discussed for the O1A visa. Now, for the O1B visa, you could also submit other comparable evidence to show that you qualify for the O1B, because there are so many different like types of industries, and these criteria may not all of them may be applicable to your particular situation. So the government allows you to submit other comparable evidence to show that you are kind of the well-known prominent figure, and your achievements are kind of those substantially above those ordinarily encountered. So you could submit other comparable evidence to show that you qualify for the O1B visa. Perfect. So now let's just go quickly over some major differences between the O1A and O1B visa. The one of the biggest differences is that just kind of like the fields you work in. For the O1A visa, to qualify for the O1A visa, you need to work in the field of sciences, education, business, or athletics. And the O1B visa is, as we mentioned already, kind of visa for artists or people working in the motion picture and television industry. Then another kind of different thing is the standard. So the standard for the O1A, as we discussed, is higher. So you have to show that you are one of the small percentage of the field, of the people who have arisen to the top of your field. And then the standard for the O1B visa is just, is just lower. Kind of the same thing for both visas is kind of the period for how long they can be issued. So initially, both the O1A and O1B visa can be issued for 3 years. And then the visa then can be extended either for 1 year, or if you can show that you'll be kind of working on a new set of projects, or your position in the company is kind of different, then you could try to apply again for like a new O1 and get 3 years again. And with regards to your family members coming to the US, so your family members, your spouse, and then your children under the age 21 can come to the US on both the O1A and O1B visas. Perfect. So now let's discuss the EB1A green card. So the requirements for the EB-1A green card are very similar to the O-1A or O-1B requirements. So I will not be going over those now, but I want to go over kind of like the analysis, like how USCIS is adjudicating these types of cases. So USCIS uses what is called or performed like what is called a Kazarian analysis. And they kind of look at these cases in two steps. So in step one, the USCIS officer will kind of examine the evidence you submitted, and they will, you know, like look if you are meeting at least 3 of 10 EB-1A criteria. If you do not, you know, if you haven't submitted evidence that you meet 3 of the 10 criteria, you only submit evidence that you meet 2, you know, then they will deny the case. But if you submitted evidence that you meet the 3 out of 10, you know, they will move to the second step of the analysis. And in the second step, the USCIS officer will look at the quality of the evidence in making kind of like the final decision whether, you know, you qualify for the EB-1A green card and whether you are really kind of like one of the very, you know, top of the people in your industry. So, you know, for example, if, you know, if you submitted evidence that there are media articles published about you, you know, in certain media outlets, you know, that could be sufficient for the step one. But in the step two, the USCIS officer will kind of like look at, you know, like what is the media outlet? Like, you know, is it like Forbes or is it some local kind of like journal in your country? And, you know, how many people read this media outlet? And, you know, so they will kind of really look at the quality of the evidence, and then they will, you know, kind of like look at all of this together and make a final decision whether, you know, whether, you know, you're one of the very few people in top of your particular field. So yeah, that's it for the O-1A, O-1B visas and the EB-1A green card. And now I will leave it to GA.
Great. Thank you, Michaela. So yeah, let's look a little bit at national interest waiver visas. So it is the national interest waiver visas has become very popular among entrepreneurs who would like to apply for a green card. And one thing to note is that the degree of prestige that is and the recognition that is expected for an NIW applicant is a little lower than what is expected for EB-1A applicants. So that's one of the reasons why it has become so popular. But yeah, let's look at the requirements first. So the first requirement that each applicant for the NIW must meet is the EB2 threshold requirement to qualify in the EB2 category before you would even get into the national interest waiver analysis. So in order to qualify for the threshold requirement, the minimum requirement, the applicant must have an advanced degree or its equivalent. And equivalent of an advanced degree. So an advanced degree means a master's degree or above. So a PhD would qualify, an MBA would qualify, a JD could also qualify. The equivalent of that is a bachelor's degree in your field plus 5 years of progressive work experience after your bachelor's. So if you have 5 years of work experience, but after that you get a bachelor's, then the 5 years preceding the bachelor's would not count towards this analysis. Now, even if you don't have an advanced degree or its equivalent, there is another way to meet the threshold requirement, which is by showing that you have exceptional ability in the sciences, arts, or business. And to prove that you do have exceptional ability, you will show that you meet 3 out of 7 criteria. So, and I'm not going to read all of these criteria, but some of the most common ones that people qualify under is 10 years of experience in your field, receipt of high salary compared to others in your field, and showing that you have earned recognition for your achievements in your field by your peers, industry actors, or government actors. And this can be shown in a variety of ways, also through expert testimonial letters or media articles talking about your work. And so that would be the minimum evidentiary criteria that you would need to present in order to show that you have 3 out of the 7 criteria. But there is also a second step analysis where the government will look at the totality of the evidences and analyze whether all of the evidences taken together establish that you have a degree of expertise that is, quote unquote, significantly above what is ordinarily encountered in the field. Now, and it is worth noting here that the standard for judging exceptional ability is lower than the standard that we just discussed in preceding slides about extraordinary ability. So now, assuming that you have met this minimum threshold requirement to get into the EB2 category, the next step for your application is to show that you actually qualify for a national interest waiver. And the national interest waiver is basically an exemption from the normal labor certification and job offer requirement. By that, I mean, there is another category of employer-sponsored immigration petitions where someone would come in with a job offer, and then what the employer would do, the company would test the U.S. labor market to see if there is a suitable replacement in the U.S. labor field of workers, the pool of workers. But if you show that you qualify for a national interest waiver, this onerous process, which can take years, is exempted for you. And to show that you do qualify for the national interest waiver, you need to meet 3 requirements. So the first requirement is that you need to propose an endeavor, like a work plan that you will be doing in the US, and you need to prove that it will have substantial merit and national importance. And substantial merit and national importance can be shown by a wide variety of fields in business, health, education, science, and tech. And really, it runs the gamut of all of these fields. Now, you can show, for example, that your work will further human knowledge in some of these key areas, such as medical advances in civil engineering, for example. You could also show that your work in the US prospectively will have a strong economic impact. You will create revenues, create tax revenues for local and federal governments, and you would create many jobs for US workers. That could also be a positive impact. So the key questions that you would be asking here is, what is the future impact of your work, and how would that be important to the US? And to support that, it is common to pull reports by government agencies, identifying what are the strategic areas that the US government thinks is important, for example, environmental sustainability, key industries such as aviation, semiconductor industry, mobile technology, 5G, AI, all of these things would come into play when we were building the argument of why your work is in the national interest. So once you have established that part, which is the first requirement, the second requirement that you want to prove is that you are well positioned to advance the endeavor. And by that, you would point to evidences regarding your education, experience, your past achievements in your field. If you have authored any intellectual property, such as research papers or patents, those can also come into play. Specifically for entrepreneurs, another compelling piece of evidence you can suggest is if you have created strong revenue growth and job creation in your prior entrepreneurial endeavors. And for example, if you have gained admission to any prestigious incubators or accelerators, those types of evidences could also be very favorable for the well-positioned prong. Now, the third requirement is to show that on balance, it would be beneficial to the US to waive the requirements of a labor certification. And this third argument is if you're an entrepreneur, you do have an edge in arguing this third prong, just because what an entrepreneur does is you create a business and you do hire US workers, which brings further benefits than saving one position for a US worker that could replace you. So by waiving that requirement for you and letting you come to the US and develop your business, the US government is actually creating more jobs than it would have saved by imposing that requirement for you. So that is how an entrepreneur can successfully argue the third prong. Now, expert opinion letters. That is a common question that we get when clients are shooting for an NIW, a national interest waiver. Expert opinion letters are a very important part of the application. So who would be writing those letters? So a key consideration is that this individual who is writing an expert advisory opinion letter should really be someone who is operating at a senior level in the industry, either in the industry or if in the academic field that is related to your endeavor. Doesn't really need to be Nobel Prize winners, but it really should be clear that this person has the expertise at a senior level that is required to provide a comprehensive and compelling judgment about the merits of your work, the prospective impact of your work, because one of the important points that you must make is that your work, the benefits of your work, do not stand at just benefiting your immediate clients. You must also show that your work will generate larger impacts to the entire industry as a whole, or substantial impacts to positively influence the economy as a whole. So those expert letters can really help build that argument of how you will do that. Otherwise, your plans could sound speculative, and expert letters are a great way to really provide more support to that. Okay, so now that we've discussed a variety of categories, including the O1A, O1B, EB1A, and the national interest waiver, EB2 green card category, let's talk about some of the considerations that come into play when deciding which category you should apply for. The most important consideration is, what are your plans in the US and what is the interest in living and staying in the US? Do you want to stay in the US temporarily? For example, do you have a business project that you need to be active in a foreign country such that you cannot just stay in the US permanently or long term? You could want a non-immigrant visa that would give you more freedom to go back and forth and give you more options to stay longer in that foreign country if that is within your interest. And so EB1A and NIW, by contrast, is not a non-immigrant visa. Those are green cards and is really meant for people who want to live and work in the US in a permanent basis. So if that is not within the plans, it may not be a favorable option for you. On the other side, there could be individuals who really want to have that permanence in their status in the US, and perhaps that could be really valuable for them. In that case, instead of the O1A, O1B, which are non-immigrant visas technically, you may want to go for the EB1A or the NIW. Another important consideration is whether you have a US entity that can act as the petitioner for your petition, or do you want to self-petition? And for some people, they might not have a US employer or agent that they can use to act as a technical petitioner for a O1A petition, for example, or an O1B petition. In those cases, the EB1A and the national interest waiver could be good options because the applicant himself or herself can act as the self-petitioner to put forth the application. And the final consideration you may want to take into account are work authorization options for families. So for example, for the O1A and O1B, it is possible for your spouse to join you as your dependent on an O3 visa. However, although your children could go to school in the United States. Your spouse, unfortunately, cannot get work authorization to engage in employment on their own. By contrast, for the EB-1A and NIW options, which are green card options, you can include your spouse and minor children under 21 as beneficiaries for green cards as well. So once you get a green card, your family members also can qualify for a green card, and that would give them maximal freedom to live and work in the US permanently. All right, so then let's talk a little bit about more practical considerations when moving from a non-immigrant visa to a green card. So the first thing that we do want to emphasize is that the EB-1A, and especially for the EB-1A, the qualification standard is different from the qualification standard that applies for the O-1A. And really, even though the language of the criteria are phrased very similarly, it is worth noting that the EB-1A, when the USCIS is looking at an EB-1A petition, they will look at each category with a stricter eye than when they do with the O-1A, looking at an O-1A petition. So in practicality, qualifying for an O-1A does not automatically qualify you for an EB-1A. So that is a very important distinction that, and it is a common misconception that we see, that some clients may come in and say, okay, I got an O-1A last year, now can I switch it over to an EB-1A? That transition may not be so automatic. There may be strategic considerations, for example, to strengthen your profile before applying for an EB-1A, just because it is harder to get qualify under that standard compared to the non-immigrant visa. Another issue that you should think about is timing. So for example, if someone is on a different non-immigrant status, and if you are thinking of extending that non-immigrant status or changing to a different non-immigrant status in the future, filing a green card application such as an NIW or an EB-1A could pose certain risks to extending that visa status or changing to a new non-immigrant visa status in the future, because a very important consideration when you're applying for a non-immigrant visa status, especially for some statuses like F1 student visa or a TN visa, showing non-immigrant intent is very important in that evaluation. And although just filing a standalone I-140 should not automatically negate that non-immigrant status, still your petition, your application for a non-immigrant visa may be subject to greater scrutiny by the government if you have an immigrant visa petition filed. So that is certainly a consideration that you want to consult with your lawyer with to make sure you know all the risks and benefits involved in filing for immigrant visa, immigrant petition through an NIW or EB-1A category. All right, so another issue related to timing is regarding family beneficiaries. If you have children who are under 21 who may benefit from the green card, it may be worth it to apply early, such as to minimize risks of them aging out, such that they cannot benefit from that derivative green card status. All right. So entrepreneurs, are extraordinary ability categories available for entrepreneurs? And the answer to that question is a resounding yes. And in my experience over the years, the regulations have become a little bit more friendlier to allow entrepreneurs to prove their extraordinary abilities under the EB-1A standard, or to prove that they are engaging in endeavors that are in the national interest and have national importance and are well positioned to advance such endeavors. And the USCIS has made it easier for entrepreneurs to apply to this by announcing announcing specific evidentiary criteria they can use to prove their merits. For example, incubator admission, accelerator admission, proof of investment, proof of job creation, and proof of revenue generation. All of those can be used in support of an NIW petition, for example, to support the merits of your work. And another important consideration here is that both the EB1A and NIW categories allow for self-petitioning. And self-petitioning is very attractive for entrepreneurs because if they own a part of their own company, that means they cannot benefit from the traditional route of employer sponsorship through their entity. So the EB1A and NIW could both prove a solution to that. It is also possible to apply under the O1A category, the non-immigrant visa option, as an entrepreneur if you have a U.S. company that is willing to act as the petitioning entity, right? And it is important to note that it is possible for an entrepreneur to have ownership of that O1A petitioning entity, and it will be still fine to apply practically to apply under that entity to act as the petitioner. And in our experience, we have seen success in using that argument, so that remains an option for entrepreneurs as well. Okay, so that is all of the contents that we had to cover today. Let us see if there has been any questions.
Yeah, I think there is one question. So it asks for a green card through EB1B, I think EB1A. What documents do the sponsor organization need to provide for an I-140 application? So maybe I can talk about the EB1A and UGA can talk about the NIW.
Sure thing, yeah.
So for the EB1A, so as GA mentioned, the important thing to realize is that you can either a U.S. company can petition you for the EB1A green card, or you can also self-petition yourself. So the important thing just to realize is that you don't even need necessarily a U.S. U.S. company petitioning you. You can just self-petition yourself. But if a U.S. company is sponsoring you for the EB1A green card, kind of the documents we usually submit is just kind of like information about the company, maybe just like website screenshot, things like that, and then it's not necessarily an itinerary, but more like a letter outlining what you will be doing for the company in the next 1 to 3 years. Just to kind of show that you will continue to work in your field of expertise. And then we also usually submit, just an employment contract between you and the company.
Yeah, thanks, Michaela. Yeah, and the similar considerations would apply for the NIW, for the EB2 NIW petition. It is also possible both ways. The individual beneficiary themselves can act as the petitioner, so that would be a self-petition. But also it is possible for one company to sponsor the beneficiary and act as the petitioner, applying on behalf of them and requesting a national interest waiver on behalf of them. So I would say the vast majority of the cases that I work on are actually self-petitions, but there could be some cases where it makes sense to have the company entity act as the petitioner for the NIW. And in those kinds of cases, yes, as Michaela mentioned, one of the things we would include is information about the company, kind of building the narrative of what the person's role will be in that company. We would also submit an employment contract evidencing the relationship between the petitioning entity and the beneficiary who will be working there.
Okay, perfect. Sounds good. Yeah, so if there are any kind of last minute questions, please feel free to put them in the chat box. But if not, thank you everyone so much for joining us today. And yeah, thanks GA, and have a good day, everyone.
Bye.
Thank you. Bye.